I want to share with you a secret. The secret of one thing that will get an attorney disbarred and thrown out from practicing law here in the state of New York. You want to know what it is? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The one secret, the one thing that is going to get an attorney disbarred and thrown out from practicing law in New York is if he steals clients' money. That's the basic premise. An attorney has a legal obligation, has an ethical obligation, that when he receives a client's money, he now has an obligation to store that, to put that in a trust account. And that's a special account. We call that an escrow account. Now, what does that mean? It means we have a requirement to hold that money. And now, depending upon what type of case this is, now we have to hold it until certain things occur. So now, let's say it's a medical malpractice case. For 3 years, you've been litigating your case. Now, finally, right before trial, the defense finally makes you an offer that you agree, you accept the offer before actually going to trial. And a few weeks later, after all the paperwork has been sent over to the defense, now they send your attorney a check. And that check is made out to both your attorney and to you. Now, why is that? Why isn't the check just made out to you? Well, it's not made out to you because if the check was made out to you and sent right directly to you, now the attorney is going to have to chase you for his fee. So in order to avoid that, the check is made payable both to your attorney and to you together. So now, what does the attorney do? The attorney has an obligation to have you come into his office in order to sign, to endorse that check. And he also has to sign it and endorse that check. Now, many injured patients are not going to come into the attorney's office just for the sake of signing the back of the check. So instead, they'll give the lawyer permission. They say, listen, hey, Mr. Jones, my attorney, I want you to go ahead and sign my name to the check. Here, I'm giving you written authorization that you can do that. Fine. Now the attorney can ethically go ahead and sign your name, saying, my client, John Jones, has given me permission to sign his name to this check. Excellent. Now he signs it, and now the attorney signs it on behalf of the injured client. And now what does the attorney do with the check? He is then required to take that check, not put it into his own business account, into his own law firm account, or put it into his own personal account. That would be unethical. Instead, the lawyer has to deposit that check made out to both people, the law firm and the client. Now it's been signed and endorsed by both people, and now it goes into a special trust account called an escrow account. And that is a sacred account, which means you can't write a check to cash from that account. If you do that, that's a trigger that something is wrong. An attorney who writes a check to cash for himself or to anybody else out of that trust account sends red warning signals to the bank, sends red warning signals to the grievance committee that oversees these lawyers' trust accounts. So what happens then once it clears? Once it clears, now the attorney has to prepare calculations. Calculations of how much his expenses were to prosecute your entire case. And he's got to itemize line by line and account for every single dollar that he spent in order to prosecute your case from start to finish. And now he has to determine the attorney's fee. In New York, the attorney's fee in a medical malpractice case is less than in an accident case. And he's got to calculate that. And now, after the attorney's expenses are calculated, after the attorney's fee is calculated, after he has to determine whether or not Medicare or Medicaid has to be repaid any money, if there's no calculation involved of repaying Medicare or Medicaid, now the remaining amount of money goes to the injured patient. So what happens then? The attorney is then going to write 3 different checks. The first check he's going to write is for his expenses. We call them disbursements. It's the same thing. So he's going to write out a check to his law firm for those expenses. The second check he's going to write is for his attorney's fee, payable to his law firm. The third check he's going to write is to the client. Now the client gets the remainder of that amount, and it comes out of that escrow account. And now he's either going to hand deliver it to the client, either they're going to come and pick it up, or he's going to make arrangements to have it overnighted. So now, whether by FedEx or some other delivery service, now the client can get it immediately. That's how the process works. So when that check comes in, you can't take that and go ahead and put it into your own personal account. You can't take that and put it into the law firm account. Instead, it must go into an attorney trust account. And the quickest way for an attorney to get disbarred is to do one of the things I told you he can't do. Write a check to cash, or borrow money from the account, from the trust account, that sacred account, to use it for something else. Who knows, maybe gambling debts, maybe pay off somebody, maybe pay his expenses. Whatever it is, an attorney cannot, under any circumstance, use that money that's sitting there for the client. And nor can he take his own money until his client has been paid. That's what attorneys are supposed to do. So, let's go back and answer the quick question. What is the quickest way for an attorney to get disbarred? It's to steal a client's money and not give it back to him, not give it to him when he's supposed to. And if he tells the client, hey, listen, your money hasn't come in yet, meanwhile, he's deposited the money, he's forged the client's signature, he's taken that money or taken part of it, and now who knows what he's going to use it for? That will trigger an investigation once the client complains to the Bar Association, to the grievance committee, and now they're going to look into it, and the attorney then has to justify and explain every single thing that went on from when he received that check up until the time that the client complained. So why do I share this great information with you? I share it with you just to give you an inside look at what goes on. Once you've prosecuted your case, once your case has been resolved, once you've settled your case, and now the defense has given you a check that you have agreed to accept to finish off your matter. You know, I recognize you have questions or concerns about your own matter. Well, if you're already at the stage where you have settled your case or about to settle the case, then don't call me because I can't help you. In all likelihood, you have an attorney. And if you have questions, then I encourage you to go and speak to your attorney about those questions. But if you have not yet started a lawsuit and are contemplating, thinking about bringing a lawsuit because of someone else's carelessness that caused you harm and injury, and now your matter happened here in New York, and you do have questions, what I invite you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.